From the Library of Congress in Washington, D.C.
Hello, everyone. Can you hear me? So we're going to start the last session a few minutes early. Maybe we'll get out of here a few minutes early. We'll see. So welcome to the concluding session called Where Do We Go From Here? I'm Katie Alvarez. I'm an attorney with the Copyright Office. And
I'm Matthew Barblon, the director of the Center for the Protection of Intellectual Property at Mason Law.
And so as you can see, this panel is a little different. We're the two moderators, and you guys are all the panelists. So Registrar Palante had mentioned earlier that moral rights aren't really talked about that much in the United States, and that today's symposium is the starting point of that conversation. So now that you've had a whole 8 hours to digest everything, we want to turn it over to you and hear what you think. So what's next for moral rights? Kind of some questions that I had come up with. So is the status quo good enough? Do we need some changes? Is that change legislative? Is there room for any voluntary or non-legislative initiatives? Also, are there any issues that came up today that are especially important to you, or issues that came up that sort of raised more questions since we covered a lot? So then to start off this conversation, Matt's going to go through a few highlights from today's symposium.
So before we open up the open mic session, I think it's helpful just to go over a couple of the highlights, some of the things that stuck with me from today's session, just to jog people's memories and to give you some ideas for comments and for your thoughts on these issues. So before I start that, I just want to say that the things that I mention are neither exhaustive nor particularly well curated. They just happen to be the things that stuck out to me, and I hope that talking through some of the comments that were made and the ideas that were raised will help all of you think of your comments for what we could do going forward, or any thoughts or complaints about things that were said today, and of course your helpful advice about what the Copyright Office should do in the moral rights space. So we heard from a wide variety of viewpoints today. We kicked it off early on. We heard that moral rights are like the Zika virus. Ideally, we would eradicate them completely, but at a minimum, we should keep them outside the U.S. And we also heard about some of the philosophical difficulties of wedging moral rights into the United States' dynamic view of property that has historically favored unencumbered and freely alienable economic rights, but about how despite that difficulty, there still is a space for moral rights in American law. We heard from artists about the difficulty in separating the economic from the moral. Attribution can be key to the development of an artist's brand, and it's something that can help artists put food on the table. And a great example to take away there is that if you write a song about getting stoned, you don't want people to think that it was a Tom Petty song about getting stoned. We heard about how we might convince France to bring a WTO action against the U.S. For failure to comply with Burns' Article 10 permission to quote. We learned about the maximal monkey agency approach to authorship, and how if we are going to have a right of attribution, the importance of having a solid understanding of who the author really is and who we're going to attribute to. We talked about how the Daystar case took away an already barely plausible argument we had that we were in compliance with Burns' moral rights requirements. And we discussed whether acknowledging moral rights would break the internet, and kind of the takeaway there was David Lowery's quote, if the internet is the most amazing thing ever, it should be able to withstand artists asserting their moral rights. We talked about the connection between moral rights and the incentive of not just to create copyrighted works, but also the incentive to publish and disseminate those works so that other people can have access to them, whether for free or by paying. We talked about, things that can step in to fulfill the role of moral rights in the absence of an actual moral rights regimes, things like collective bargaining and contract law. And then the last thing I'll leave you with before we open up the floor to comments and thoughts is we learned about why the most common artist on Sirius Radio is various artists, and how a robust moral rights regime could change that. So with those thoughts in your mind, we'd love to just get ideas from people in the audience about steps that can be taken, avenues that could be researched, or things that the Copyright Office could do to delve deeper into the moral rights space.
And also, I know we didn't have a lot of room for questions and answers during the other session, so if someone has something that they wanted to bring up earlier and didn't get a chance, now's your chance.
And if nobody has thoughts, I'm happy to call on people.
Hi, so I kind of come from the perspective of the artists and talking to artists about what they know about their rights. And what's interesting to me, and it kind of stuck out to me, was when Professor Ginsburg said that most people think that they have the right of attribution when they really don't. I will say that most artists, they get told, oh, I don't have to respect your copyrights because I gave you attribution. And so artists are extremely confused. They think, oh, do they just need to give me attribution, or do I still have a right if they use my image in a way I didn't want to use it? Which says to me that there's a big need for education in this field as well.
Yeah, I think that's right. I think education is key, and it and the confusion that can easily develop among the people that stand to benefit both from copyright and from moral rights is something that persists, and at a minimum, even if we're not going to make any changes to the law, it's helpful if people understand what their actual rights are. All right, Sandra?
So I thought I'd maybe make a quick comment about one theme that kept coming up, and that is what's the public's benefit from moral rights. And as I listened to people answer the question over the course of the day, a couple of thoughts came to mind. First, I think if you think about what the public's benefit might be, an easy answer to that is the truth, right? We get to know whose work it actually is and how to access that person if we want to interact with him or her, either in the capacity of a fan, buying tickets to David Lowery's show rather than Tom Petty's show, or in the capacity of a potential licensor of the work. But one thing that I kept having in the back of my mind is a conversation that my clinic students and I had with photojournalist Yoongi Kim. She's a Pulitzer Prize finalist and a conflict zone journalist. And this was in the context of comments we were submitting to the Section 512 study. But what she told us was that one of the things that is most troubling to her when infringements of her works occur is that the work is often misrepresented for something that it is not. So for instance, she has a very famous image of a young boy in Kosovo, and that image has been taken by various, either revolutionary groups or other groups and represented as something else. One instance, it was, represented to be a Palestinian boy rather than, accurately reflecting, the truth of the matter. You hear about these stories also in other contexts. I mean, when the Boko Haram kidnapped the girls in Nigeria, the first thing that popped up on Facebook was an image of a completely different group of girls that was, used to represent these, Nigerian kidnappees. I think the public loses something if you can't rely on a photojournalist's image actually being what it purports to be. And to me, I wonder, which of these rights really addresses this? To some degree, I think it's an integrity issue, but the image isn't necessarily altered. I guess it's put in a different context. I'm not sure that the attribution issue helps us any, because just the fact that it's attributed to Yoongi Kim doesn't resolve the fact that the work is being represented in a way that's inaccurate to her subjects. I'm curious whether others have, thoughts on how this might be addressed, and whether that's something that is already kind of within the sphere of what we're talking about in terms of moral rights.
And I'd add that ties back into the point that Professor Ginsburg was making in response to one of her questions, that when you're trying to justify potential legislative or other action in the moral rights space, it's not just the fact that we arguably aren't in compliance with the Berne Convention, but also that there is a legitimate public interest in it, or at least there are many arguments you can make for a public interest.
I'll speak to that in the context of writers, and in terms of the rights of attribution. This is something that I have been aware of during the course of time that I've been a writer, and it addresses the notion of ghostwriting and people who write with other people. And I remember 25 or 30 years ago, you would see a celebrity biography, and it would say, "as told to." It was Rin Tin Tin, as told to David Johnson. So you knew it was not told by Rin Tin Tin, it was actually written by David Johnson. Then that became blurred, and now the celebrity biographies or memoirs or autobiographies all say by Elizabeth Taylor. And again, if we're talking about giving the public the truth, everyone knows that this celebrity didn't write the book. That's public knowledge. And yet, the book is published under that person's name. So the ghostwriter has lost all professional sense, no ownership of the work, no moral right to attribution. And I know of one person who wrote a celebrity biography, and he told me every time I would see him, I'd say, "How's it going?" And he'd say, "It's great." And I said, "Where's your name going to be?" And he'd say, "On the front of the book. It's going to be a joint biography." It came out without his name anywhere. And it just gradually sort of the tide receded, and he just didn't get it. And I know of another one in which the man died, the writer died just before the publication, and with only the widow to protest, they just took his name off it altogether. So the public loses there in terms of the sense of truthfulness and authenticity. And why should we be party to a system that just withdraws the sense of truth from the public? Yeah.
And just to add something to the public benefit of the right of attribution, it has been the common practice in the publishing industry to provide attribution except for these ghost-written books, and that which is slowly changing. But most authors write in part for the right of attribution. I think if we were to survey our members, they would say that they probably wouldn't have gone into writing if they hadn't thought that their work could be attributed to them. Now, midlist writers are having a harder and harder time economically, and there are just fewer books being published on serious subjects for midlist authors. But so many of our members, particularly members that have written many books in their 50s and 60s, are starting to write books without their name being put on the book. They may be, often they're rich people who just want a book written by somebody, and they want their name on the book, not the actual authors. And yes, you will find authors willing to do this because they need to pay the mortgage, or in many cases, I have friends who say they're doing this because they, their kids are in college, and then I'm going back to writing my own stuff. So I think an important thing to remember is it's also an incentive. That's my point. It's as much of incentive as the copyright right.
Yeah, I think frequently, at least for many commercial artists, we lose sight of what the end game is in all of these discussions. And for me as a commercial artist, copyright and moral rights ultimately are, I guess, a means to allow me to continue to profit and to profit from my creative works. And so they're a means to an end, and they're not the the end. And I think in that direction, we need to support efforts to, as Nancy spoke about, persistent identifiers, and it gets even more cumbersome. It's more like a machine readable persistent identifiers. So they're identifiers that are persistent and can work in the background and don't require human intervention to enforce rights, and ultimately you're able to manage, or at least visual artists would be able to manage a lot of these downstream uses that we were talking about today, the secondary uses of images where right now it's the total Wild West, and photographs are just being used willy-nilly. So.
Looking at it from a slightly different point of view, I'm a litigator, and I do this from a more practical point of view than the esoteric. And when you have people having misattribution or non-attribution, they start killed us on one whole good creative set of arguments. But one of the other problems you have is the preemption. Like when I try to file, or if I'm on the defendant on my 12b6, is going to, when people try to use unfair competition or other kinds of things, I say, hey, it's preempted, or it's a problem I have if I want to plead it, because this is all subject of the Copyright Act, and it is not included. So the various different kind of creative elements or arguments that one might make, I'm not real sure that because of the preemption that they would get very far. So just a little practical thing there.
Someone in the back.
Hi, my name is Meera Sundararajan. I'm a professor of intellectual property law at the Create Copyright Centre in the UK. And I've written a not insubstantial book entitled Moral Rights Principles, Practice, and New Technology. For that reason, have a number of thoughts, but at least a couple of which I'd like to share in the limited time that we have available. One of them is that I've been listening with a lot of interest to these comments about what is the public interest in moral rights, an issue I talk quite a bit about in my book, and I think it's a key question that we need to be able to answer. We heard from the authors, we know how they feel about it, we know to some extent how our middlemen feel about it. How does the public feel about it? And for me, the important point that we need to remember is that all works eventually end up being owned, in a sense, by the public. They go into the public domain, all copyright works. And that idea was expressed by Victor Hugo, who said that the true heir of any writer is ultimately going to be the public. And I think when we think about the issue of moral rights, it's helpful to keep that in mind, that preserving the attribution of works, preserving historical truth, preserving the integrity of works that are in the cultural domain is something that ultimately is a matter of importance for every citizen of a country. Another issue here that may be apt as well is that American artists are in a curious position, because when you go out of the country with your work, let's say you go to France, your moral rights are recognized. And yet here in the United States at home, you don't have the same rights that you enjoy in foreign countries. And I'm Canadian, we have moral rights. If I were an American creator, I think I'd be quite upset about that situation. So I do think that there's some national pride, cultural pride involved. And maybe that goes to a final interesting point, which is what we're talking about here is cultural diversity. Well, let's not forget that cultural diversity also exists in the law. And that has been maybe an interesting backhanded development as far as the relative exclusion of moral rights from TRIPS is concerned, because countries have adopted moral rights in keeping with Berne and TRIPS, but there's tremendous diversity in how different countries have implemented moral rights. I mean, literally, it would be difficult to find two countries that have done it the same way. And you have everything from the UK situation where you have to assert your right of attribution before you can expect to have it recognized, to the situation in India where rights of integrity are protected forever. Why are they protected forever? Well, the Indian Copyright Registrar told me that amendment was brought in for a specific reason, because the interest of the public in the preservation of the cultural domain was considered to be so important that integrity had to be legislated for time immemorial. So we have so many different approaches, and I think that at least should be very encouraging here in the United States, because there's so much that can be done to recognize moral rights and yet to give them a shape that makes sense in the cultural, technological, social, economic context here in the States.
Thank you. And can you remind us the title of your book?
An easy question to answer. It's called Moral Rights. The key words being new technology, and it's published by Oxford University Press, just about to come out in a second edition, so please don't try to buy it until a few more months go by.
Any more comments or
We have one
suggestions?
hiding behind the pillar
No,
here.
excellent.
I just wanted to speak to a form of expression that I hope becomes part of the conversation moving forward, and that's dance. I think the absence of that in the conversation today is probably, it's illustrative of the sort of lesser degree of pervasiveness in culture than something like music or books, but that was, I think, largely an accessibility issue in the past, and with an increased focus on digitized entertainment and technology, and with content hosting sites, I think dance finally has the means and window of opportunity to be able to reach a broader audience and disseminate their work on a greater scale, and in terms of protecting the rights of music and sound recordings and musicians and performers, I'm hoping that dance will be a consideration so that they can take advantage of this opportunity and finally, have their moment and push their way into society and culture and become more pervasive.
And Brad, we have a question over here on the left.
Yeah, just one or two quick thoughts. One is that the discussion has talked about incentives a good bit and interests of various groups, public or other maybe. But the term itself as moral rights, both of those words are very interesting and useful too. And I think, going forward, fuller use and could be given to those both of those terms. I think of the, sort of historic American principle in American law that rights are not only something that government would give or take away on a whim or based on particular interests, but that there are certain rights that, in here, I think there was the quote early on about a person being entitled to the fruits of their labor, and so I don't recall exactly the quote, but then the other point that I was going to raise was that it just seems to that law can have a teaching function also, so that even if there's not a very elaborate complicated system that is put in place right away, I just giving some protection to moral rights can help to remind people that this is something that is something to be valued, because I think so often if the law doesn't require something, they'll give a copyright notice or something, but they won't give recognition to the authors because there's no feeling that they should do so.
Thank you.
Anyone else?
Oh, we got one in the back.
One in the back.
It's more of a comment than a question. I was just thinking about the two panels ago, contrasting the public art, the mural, and the relationship of public art to moral rights as opposed to the relationship to the digital arts. And I was looking at thinking that in terms of my own comments about how moral rights relate to communities, and I thought that was a very interesting illustration of the difference between when you have something that's based in the community and how people relate to the rights. as opposed to when it's just floating around digitally. And it's interesting that dance was brought up because dance is in a sort of middle position right now because, well, I'm talking about street dance in particular, which is one area I'm interested in. It's in this, it's still a community, but it's kind of like a worldwide community, and attribution, everybody kind of knows who's making up the steps because they're getting uploaded so quickly, but they're also getting disseminated very quickly at the same time. So I'm wondering, it seems like maybe that's actual beginnings of a solution of crossing those things. Looking at dance might be a way to kind of think through actual solution there.
Any last minute thoughts, comments, questions?
Oh, yeah, we have two more, Alan and Mary.
I have just a question for everybody here, and that is, after seeing Scott Morton's presentation about all the different laws around the world, at lunch we were talking about, potential need for unification of IP laws. Is there any interest in a international treaty on moral rights? And has there ever been discussion? And I know there's some people here who might have some thoughts.
Other than the one we already actually had. And we complied.
Oh, is it? Okay, yeah. Other than the current, but a treaty specifically on moral rights.
Alan?
This is a question I probably should have asked to session 5 when they were up there, but it occurred to me, one of the major developments, at least for my industry, since moral rights was the source of major discussion here in the United States, is the fact that the internet has given rise to a new generation of self-publication. And I'm just wondering, in that environment where the author essentially also becomes the publisher and the person chiefly responsible for distribution of their own work, if that makes a difference in the calculations that people would make about, well, certainly I think it would with respect to integrity issues, but I'm wondering if it would also make a difference with respect to attribution issues as well.
Maybe the last comment?
Good afternoon. It's not comment, it's just an inquiry. I'm not a lawyer. I came to attend this symposium. It's a course for me, so I was really inspired by each speech from all of you. So I have a question. I was trained as a biologist. So in the international collaborations, I see some lack or gap between the policy and the law. So here we talk all the day about law, copyright law, moral rights law, attribution, the law, but how about the policy? Here I would like to present you a scenario from the US Office of Research Integrity. I would learn a few months ago in this office, there's a policy, the plagiarism, if put in this room, would be a real plagiarism, but there they didn't see it as a plagiarism, but authorship dispute. They say that the ORI, the Office of Integrity, Research Integrity, considered many dispute between the collaborators in the same research project as an authorship dispute or credit disputes rather than the plagiarism. So I would ask your insights, how could make the interaction between policy and the law? Thank you.
I don't think we're going to answer that question today.
But
But
thanks for raising it.
yeah, thank you. I want to thank the panelists from the last panel and the audience. Also want to thank all of the panelists who've been here throughout the day, as well as the audience. I think, as I said, when I first started the overview session, I didn't know whether we would actually have enough to discuss for a full day of moral rights in the United States. But it not only showed that we actually have a lot to discuss, but a lot of important information, and really showed how strongly people believe that, especially the moral rights of attribution and integrity, are to individual authors. So you've given us a lot to think about. As I think Registrar Palante mentioned, at the beginning of the day, this is only the beginning of our conversation. We'll now take some of the things that you guys have said today and use that to actually ask more specific questions in terms of what should we do next as we analyze moral rights in the United States and we consider how best do we actually protect both individual authors as well as the public in terms of wanting to know who creates the work and how the work is being used. So thank you again for participating, and thank you all for coming.
Thanks, Karen.
This has been a presentation of the Library of Congress. Visit us at loc.gov.